Hello.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican por service love you.
Is that correct?
literally not true.
I didn't ask you to interrupt me. From sake.
Alex stole it, and Ellen Murdoch stole it. Alex stole it as well.
All right, good morning. Welcome. Sorry, I just wanted to push those 3 buttons. Welcome to the Court of Public Opinion. I am the Recovery Addict, and I'm sitting in the dark, apparently. There we go. That's a little better. Let's see. Still dark in here for some reason. It's all right. It's all right. I'll take it. I can nap now. Happy Friday to you. Happy Friday. Congratulations. You made it all the way to the weekend. Waited for the hello before you hit go. I try to get the intro in before you start saying hello, hello. Send someone with more experience. I try to get it all in, but you guys, you're not very patient in the morning. I can tell you that much. Good morning. Good morning. Let's see. Kim, congratulations. You were first in chat this morning. I'm pretty sure it was you. You're laughing like you got away with something, and you didn't. You didn't. We're going to send it to you to internet ownership. Everything IP related is your responsibility. There we go. And now I pinned you. Hope it was you that won. So that's all right. Let's see. No pants. Check. Lumia started. Yes. Go live. Yes. Put chat on screen. Ooh. Yes. Reset counter. I'll work on that. Say hi. Did that. Recognize first in chat. That's Kim. Birthdays. Do we have any birthdays? Do we have any birthdays today? Oh, yes, we do. Never mind. We have a couple. Cass, XO, and Mike. Is it Michelle? Michel. Yeah, it's Michelle. It's Michelle. Happy birthday to Cass, XO, and Michelle. And so we're going to sing to these wonderful people. Everyone, you're going to sing with me. So stand up if it's legal and you're able. Stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me if you will. La 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 la. There we go. Happy birthday to you. Happy birthday to you. Happy birthday to Cass, XO, and Michelle. Happy birthday to you. Next verse, we're going to sing to Cass. Well, never mind. Cass, it's tomorrow. We already sang it to you. Happy birthday tomorrow. So then we just get to enjoy the music. Dancers, you're doing great. To everyone who celebrated their birthday today, happy birthday. I realize there are a million places you could be and a million people you could have been with, but you chose to be right here with us. The privilege, pleasure, the joy, that's ours. Hopefully we can turn that joy right back to you and make your day more special. Begin by helping yourself to free pancakes. At Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlop's House, Sandy's Grill, Bob Evans, and Cracker Barrel. Happy birthday. Rebecca, thank you. We're honored to be amongst your presence, to be in your presence. Let's head to Tammy's, everyone. Group, let's all hop on the bus, head to Tammy's. It'll be great. Drum solo for the big finish. Here we go. I didn't have it. I missed that one. I hope you guys did the drums well, because I completely flubbed that one. I was busy trying to see what Judge Webster was doing on her channel, and I missed it. But we're going to be going to court very shortly. In about an hour, we'll be heading down to Las Vegas virtually, taking you all with us for the next for a full day with the Duane Davis trial. Back to testimony, maybe a little bit more recordings, but back to testimony. And it should be interesting. It's spicy as well, I'm hoping. Good morning. Good morning, Judge Webster. Sorry, didn't mean to interrupt you.
So yesterday changed your mind that made you learn your lesson?
Well, that and having to be in jail again, and I finally got my kids back in my life, and I don't want to lose that opportunity. And yes, Your Honor.
Are these children with this Miss Height?
No, absolutely not, Your Honor. They're I don't have any kids with Miss Height.
All right. How did you get your kids back when you didn't have them apparently before? What do you mean you got your kids back?
I get to have visits with them again. I got in contact with their mothers, and they finally started letting me have visits.
So they're from different mothers. How many of them are there?
3.
How old? What age range?
3 mothers?
14 to 5.
And these mothers were not letting you have contact with these children?
Well, not that they weren't letting me. It's just I hadn't had a way to be in contact with them. So I finally got a way to be able to. Finally got a phone with service, and they're going to allow me to start seeing them and everything.
All right. So you violated the court's orders when I told you to report to probation and to do all these other things. You violated the court's orders when I told you on bond not to have contact. The legislature did contemplate the court giving jail sanctions. You've had 31 days in prison. Miss Morgan, has he ever had any other jail sanctions?
No, Your Honor, not on my probations. Like my documentation says, I've never met with Mr. Simler.
Well, I would like to just say I've given you too many chances, and I don't think you're going to make it. But the legislature does contemplate jail sanctions. You certainly had one now for 31 days. Both parties are suggesting that I give you the credit of those 31 days as your sanction and return you on probation in all 3 cases. I don't like that, but I do think that the statutes are designed by the legislature to give you a sanction and see if that makes a difference. How many times have you been in jail for other matters prior to this 31-day sanction?
Your Honor, there's only one other time that I was ever in jail, and it was in 2020 or 2019, and it was other than the municipal case here, but other than that, it was only for a couple days.
And Mr. McClendon, remind me, what is that municipal court case? Is that a DV or something of that sort?
Judge, I want to say it was I can't recall what it was, Judge.
Okay, well, that's fair. I know you've got a lot of cases and you've worked with him a lot. Okay. Did you say he was revoked in that case, or is it still pending, if you remember? Because I sure don't.
That case is resolved, Your Honor.
It is resolved. Okay.
If you recall, we closed that case on Monday.
All right. I didn't recall, but thank you. I thought maybe.
I didn't recall either. I missed that one.
All
Your
right,
Honor.
Mr. Simler, you stop talking because you've got me thinking. You don't have me, but the legislature has me thinking that I need to give you this one more probation chance because you haven't had a sanction.
Don't talk yourself into jail.
But it's a short rope, sir. I'm gonna go ahead. I don't. I'm not feeling good about this.
Love true crimes. Happy Friday.
My experience tells me your history does
Thank you
not
so much.
lend itself to probation, and you should just serve your sentence. But because the statutes do talk about sanctions, even though these aren't felonies, I am going to give you, as is recommended, credit. I'm going to order a 31-day sanction, giving you credit for the 31 days served. I'm ordering that you immediately, upon release, report to Jessica Morgan, unless she tells me otherwise here when she wants you to report. And that's in all three cases, all conditions as in the first two. Your probation is extended for 1 year from today and granted for 1 year in the new case. All three 1 year from today. Miss Morgan, would it make more sense maybe to transfer him to community corrections? Would they take him on 3 misdemeanors?
No, Your Honor. It would you would have to have a felony case.
All right. Well, Miss Morgan, you're going to be stuck with him for a year, or unless he screws up again and has to come back for revocation.
How do you feel about that, Judge?
Because I think I do need to give him that sanction. I think that's the intent of the legislature. And I'm not going to make that a precedent. I'm just saying that's what I'm finding in this particular case. When do you want to see him next? As soon as he gets out, or do you want him to make an appointment now?
Your Honor, once he's released, he can come see me at the courthouse on the second floor.
And you're here today, right?
Yes, Your Honor.
All right. This is on you, Mr. Simler. You've been given every chance in the book and then some.
Yes, Your Honor. I understand, Your Honor.
Judge, I think we still need to announce his 12 months, underlying 12 months probation on his case. His cost, please.
All right, please let's go back now to that other case, the new case, which is 26 CR 26, if I've got this right. What are your recommendations for sentencing, Ms. Gillette, in that?
12 months underlying, 12 months probation, court cost, booking fee, probation fee of $60, and court to determine if there's any attorney fees for Mr. McClendon. And I'm not asking for a fine. No contact order with Miss Height remains for the duration of his probation.
All right. Mr. McClendon, you're going along with that, I think you said.
Yes, Your Honor.
Mr. Simler, I'm granting you a 12-month jail sentence that you must serve unless you successfully complete a 12-month reporting probation in the 26 CR 26 and a new probation in the other two cases. 12 months of probation, you must report and do exactly what you're told to do.
Yes, Your
I'm
Honor.
not going to hear any excuses if you come back here.
Yes, Your Honor. I understand.
Oh, I'll listen to them, but you're going to have to do some real serious convincing me to do anything with them. Because I feel like you have exhausted your 3 strikes and then some. No contact with Savannah Height in any way, shape, or form. So I don't know how you're going to get to see these children. Well, you said she's not the mother?
Yes, Your Honor. She's not the mom, and I don't ever want to have anything to do with her again.
Well, that sounds like you're blaming her for being in this position.
No, I'm not. I'm not blaming her one bit at all. I don't have any reason to have any contact with her ever again in my life.
Well, don't have any contact with her. Don't do anything with these other women and the children that will make those children turn out bad in life with being in jail themselves, okay?
Yes, Your Honor, I understand.
If you care about those kids, be a good role model for them. No alcohol, no drugs. I haven't heard much about that with you, if any, so make sure you don't use any alcohol or drugs. That's a standard list of probation, that Miss Morgan's going to go over with you. If you ever show up, she'll go over it with you.
If you ever show up.
But if you don't show up, all deals are off. And
That's the first place I'm going, Your Honor.
Okay, you're going to go there every time she says. Where are you going to be living, in Wichita?
No, Your Honor, in El Dorado, Kansas.
Is that with your mom or your sister?
My sister.
All right.
My mom's the one who's going to have to help because my sister owns 2 different businesses, so she's going to be busy. But my mom's willing to make sure that I can get to probation as well.
Now, you keep talking about your sister's businesses. What kind of businesses are you going to be in?
Marijuana.
She owns a clothing store, and she also owns a maid service for cleaning law firms and things like that, and apartments for retirees and stuff like that, Your Honor.
All right, so you're going to be helping her with her cleaning service. And what are you going to do for the clothing store, if anything?
Probably going to be a manager, Your Honor.
Are you qualified to that?
Yes, Your Honor. I've been a manager for the last 6-7 jobs I've had.
All right. Well, I'm expecting this to be your probation, not your sister's, not your mom's, yours.
Yes, Your Honor. I understand.
I'm only giving you this additional chance because the legislature keeps talking about sanctions and so forth. And so I'm going to give you this sanction and see if you mean anything you say, or if you're going to do it even if you don't mean it. All right. Anything else? Oh, I do. On that new case, you are responsible for court costs, booking fee, supervision fee. I will waive attorney fees because you've been in jail for so long. But you need to make monthly payments on all 3 cases. And I'm going to let your probation officer decide how much you're going to pay each month. Because I don't know what you're going to be making. But your first payment on each case will be due September 21st to 2025 or 2026. And I'm going to expect at least $100 payment on each one, but they can make it more than that if you're able to pay it. If you're living with your sister and she's putting a roof over your head, or your mom, and they're covering your expenses, you should be able to easily pay that on each case. That's $300 a month.
All right, Your Honor.
But probation needs to look at that and see if you can could or should make more. They have discretion.
Your Honor, I don't.
Go ahead.
Your Honor, I don't think I'll be able to pay more than that because I also have a garnishment for child support.
So you don't even support your kids. Jeez.
Well, I do. That's why I have a garnish out of all my paychecks.
That's not how it works.
Well, one of your standard conditions is don't violate any laws. If you don't pay your child support, you're violating the law that says you pay child support. So you need to do everything you're told to do in your domestic case, whether it's child support or custody and visitation.
Yes, Your Honor. I understand.
All right. Anything further, Ms. Gillette, on these cases?
Nope. Did you weigh Mr. McClendon's fees?
I did.
Okay.
Mr. McClendon, anything further?
No, Your Honor.
All right. I still expect Mr. McClendon to get paid, just so you know, Mr. Simler, but the taxpayers are going to pick up the court appointment bill. Now, he's working at a reduced rate of what he would if you walked in his door. But you've got to quit putting this burden on the taxpayers of getting in trouble all the time.
I understand, Your Honor.
You got to get on your own 2 feet and start paying for your own room and board. Not the county jail, not the taxpayers, not your mom, not your sister. You do. You need to start paying for your kids.
Yes, Your Honor. I understand, and that's what I want to do. I'm tired of being like this.
All right. Well, I'm going to remember this if I see you come in here on a show cause again. So you make sure you prove me wrong, that you are going to be successful.
Yes, Your Honor.
Those people want to be proved right. I want you to prove me wrong that you're, because I'm questioning whether you're going to be successful, but I'm going to give you this chance.
And Your Honor, I would love to prove you wrong in a good way.
Absolutely.
Good way.
You do it, sir.
Just
All
stop
right,
talking.
We're in recess.
Oh, my
You're remanded
goodness.
to custody of the sheriff so they can do what they need to get you to Miss Morgan. Thank you all. We are adjourned.
Thank you, Your Honor. Have a great day.
Thank you.
How do you feel about that one?
Next one's at
All
10.
right, next one is Turner, kind of a deja vu. He's got a prelim and status conferences. I thought he had a show cause too. No? All right.
No.
She comes.
Missy, do we have Mr. Turner? Is he in jail?
No, he's not, but we got about 15 minutes before it starts.
We're ahead? Hey, that's pretty good. All right, but same codes?
Yeah, I'm just going to leave the meeting up.
Okay, I'll just close my picture and mouth.
Close my picture and mouth, she says. All right, let's see what's happening up here. I haven't been here before.
On conditions is protection of the public, and we have here a felony probationer who allegedly, soon after be putting on probation, threatened to kill a judicial officer.
Whoa.
Those are not circumstances I'm willing to treat lightly, despite the fact that they're allegations and despite the fact that you have a presumption of innocence. I'm also not willing to set this matter out a predominantly long amount of time. In other words, while your attorney might have some factual argument as to why it could benefit you, I intend to have this matter resolved. If your attorney's right that you're not going to have, the people are not going to have enough evidence to prove a violation, then I want to make that determination sooner than later. Because if they can't meet their burden, then you shouldn't be held on these charges and or these probation violations. But if they can prove those charges, then the likelihood of me continuing on probation is relatively low given everything that I've said. And I intend to make that determination sooner rather than later. So the court is going to set this matter for a probation violation hearing at my next available date. I'm going to set high cash bonds in these matters because of the circumstances and the risk to public safety given the allegations. $50,000 cash or surety will be set on each one of these files. This matter will be again set in person for a probation violation hearing at my next available date. I'll require that everyone is there in person. That would be any witnesses that are needed for proofs, and the prosecutor, the defense attorney, and the defendant, and of course I'll be there in person as well. Mr. Seeger, do you have any questions about any of the court's orders?
I do not, Your Honor.
We have
Mr. Campbell, do you have any questions regarding any of the court's orders?
Am I allowed to go to rehab?
Not until I resolve the underlying merits of this action and the allegations. Again, all of the things that I've said will relate to whether or not I ultimately grant that, including whether or not I find that there's preponderance of the evidence that a threat to kill was in fact made. I will then determine whether or not I approve of any type of release. Okay. Ms. Wagner, anything else today?
None, Your Honor. Thank you.
Your Honor, I just wanted to make clear that, and Mr. Ziegler's not there, and either is Mr. Benedict, but I can at least tell them, or probation and parole can tell them, at least as I understood your order, that any witnesses are to appear in person. And I would assume that if there's a guard from Wexford, which a communication was allegedly made, that he's required to appear in person.
All witnesses are required to appear in person unless arrangements are made with me and approved by me prior, but otherwise all witnesses are required to appear in person for this very important matter.
Wow. He's serious as a heart attack on this one. I guess he's done too. And he's done. Wow, that was it's a weird one to jump into. You threatened a judge, or what? A lawyer, an officer of the court? You threatened to kill one? Whoa. Yeah, that'll get their attention. $50,000 bonds on all your charges. Let's see. Got just a few more minutes to do a little court hopping before we have to jump down to Las Vegas. Hello, sir. Judge Elmore, how are you doing? State of Michigan, we can tell from the seal.
I believe we're ready, Your Honor.
Isaki jail. All right.
Judge, you're muted.
All right, we are back on the record for second. People versus Anthony Couch. All parties present in the court recess are again present. So what are we doing today, Mr. Root?
Your Honor, I believe that Mr. Couch is prepared to acknowledge the violation.
Is that a change
of heart? Correct, Mr. Couch?
Yes, Your Honor.
Thank you. Please raise your right hand for me. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, sir.
Give me a lawyer hand. All right, Mr. Couch, now if you make an admission, and I find that you violated your bond conditions, once again, it is not a new criminal charge, and you're not going to be criminally sentenced. The admission will only mean that I have to reassess what to do with your bond. Has anyone made any promises, threats, or inducements to compel you to admitting to this positive test?
No, Your Honor.
Mr. Couch, is it true that it looks like you tested positive for the use or consumption of methamphetamine back on August 19th, which was just a couple days ago?
Yes, sir.
And you knew that that would be a violation of your bond conditions?
Yes, sir.
Oh.
I just want to clarify, only because that would be preponderance of new criminal activity of use of methamphetamine. I don't think drug testing is ordered as part of this case.
Oh, okay, hold on.
He's on parole.
I got it.
Probation as well.
He's on probation for fleeing and eluding in the 3rd degree.
Fleeing and eluding?
No, he's on bond.
He's charged with fleeing and elude in the 3rd degree as a 4th habitual enhancement.
Yes.
Yep.
And he's also on parole or probation.
Parole.
With Misaki County.
Oh.
Yeah, you got
it. That's how the test came up, and I'm alleging that's preponderance of new criminal activity. That's
all right. Now I see. All right. So, Mr. Couch, we're going to focus here. I did not realize that you were on probation over in Misaki County. Is that correct?
Yes, sir. That's why I had a drug test.
Yep. All right. See what happens in this past week, and I failed to ask the question. This past week, our tester from Community Corrections has been out of the office, and the Department of Corrections or the probation officers have agreed to help. And I made the bad assumption that it was Miss Odell stepping in the footprints of Miss Mansky, and that's why she was conducting the testing. Has there been a allegation for a probation violation filed in Misaki County? I don't remember seeing one this past couple of days. You know? All right, let's take a look at this. Mr. Roop, do you know,
Your Honor, I was forwarded a copy of an email that was written by Miss Odell to Kathy Wright, explaining that Mr. Couch was lodged on a parole violation for a positive methamphetamine. Right now, their plan is to impose a jail sentence up to 20 days until a residential treatment bed can be located.
Mr. Couch, did you sign? So when there's a probation violation, that probation violation may be handled in the court. However, for a first technical violation, it could be handled between a written acknowledgement. Yes, sir, Mr. Couch?
It's a parole violation.
A parole violation?
Yes.
All right.
This judge is not up to speed yet.
It sounds like if it's a parole violation, then it wouldn't be in front of me. So it may be that Miss Odell serving in his role as a parole officer.
We're going to turn this off. We're going to jump to another. We're going to jump to the Panhandle of Florida. Hang on. Let's go here.
Collected items, done fingerprint analysis, and collected latent prints, and they were something to compare them to. I could understand why we would be here, but there's just nothing that was developed.
Mr. Ballard? Well, I don't know if that's true, Your Honor. There's allegedly no prints on what they're claiming he's in possession of or tied to, but I think that we should have the right to at least inspect that thing and confirm it. I know that Mr. Sullivan is saying that there are no prints on that thing, and that's why we can't compare them to his fingerprints. What thing are you talking? There's a small booklet, a coin purse thing that the pills were allegedly in, and that's what they're saying my client was in possession of when it was just in the car. He's willing to provide his fingerprints to exonerate himself, and they're saying that there's no.
There were no latent prints developed off of that item. I don't even think we would have to have a hearing. There would be no issue of comparing his fingerprints if there were fingerprints developed to compare them to. But me going out or sending an investigator out to collect Mr. Wheeler's fingerprints is going to do nothing other than put a fingerprint card into evidence with his fingerprints because there's nothing to compare them to.
I guess what Mr. Bauer, are you asking that they test the coin purse? I'm assuming that they did test it and there were none, but I haven't gotten information of that.
If Mr. Sullivan's saying there's not any evidence, I can't compel what he's saying is not there. The motion's denied. I mean, if they're telling you I don't have it, there's not there, there's nothing to compel.
Well, you
find out later on that there is, I mean, that's a violation, but right now there's nothing to compel.
And there's no way we could be granted in part to at least allow our expert an opportunity to review that to confirm.
I don't know that that they have to release any evidence as far as that. I don't know. Mr. Sullivan?
I mean, I don't necessarily have an objection to that, but I mean, how does an expert confirm that there's no fingerprints? You look at what's in evidence, there's no fingerprints. It doesn't take an expert to determine that. I just don't understand.
You're proving a negative.
Mr. Ballot can observe, he can look at.
He can go into evidence and.
Why don't you do that before you file a motion? Go look and see what the evidence looks like. And if you think you have a motion, file your motion.
I thought that we did, but
have you looked at it?
We've looked at the coins. We just haven't seen a report that confirms that there was no.
But did you see any fingerprints on it?
Not with my eyes.
How else you gonna see it?
I guess with a black light or an expert would.
I'm gonna deny the motion. You want to try it again? All right. Do we need another court date for? When you want to set this?
Can we get in September, Your Honor?
September 24th at 9 o'clock.
Kyle Valerie's here, Your Honor.
Valerie? Right, you need to be quiet. You understand? I might want to go ahead and take him back before he gets in trouble. All right, Mr. Ballot.
Yes, Your Honor. Mr. Wheeler is set for the trial docket, I believe October, November.
Okay.
Valerie.
I'm trying to have court. We ready to go forward?
Yes, I believe so,
The
Your
right
Honor.
judge.
There is, we were set for trial before, and it got continued. I filed a motion to compel the defense.
DNA.
I think it was DNA. That is currently being worked by FTLA. I haven't gotten those results back. I'm hoping we get them back soon, but as of right now, I'm prepared to move forward.
Well, let's leave it on the docket, and of course, if there's evidence that comes in after the day, we'll address that. Okay. We'll leave it on that September trial docket. Oh, it's October trial docket, so we got plenty of time. I'm sorry, Madam Clerk.
And then the last one I have, Your Honor, is Mr. Maurice Bennett.
Bennett?
Reached out to Dr. Rayleigh's office again. Mr. Bennett has told me that he's completed the competency evaluation. They found him competent. Don't know what the status is with Dr. Rayleigh, but.
Ms. Nelson, have you had any contact?
I sent him an email and I also called the office and left a very detailed message.
I guarantee you she did. Knew that without asking. Okay. All right. Let's set it for September 25th. See if we can get that information. I'm kind of stuck until I can get a report. And if we'll get it before, hopefully we'll get it before then.
And I did have one more on the trial management, Your Honor.
This afternoon?
Maybe, yeah. Courtney Jordan.
Yeah.
Jordan. She's got 2 cases.
She in custody or she out of custody? Oh, she must be out of custody.
She's out of custody, but in custody in Georgia.
Oh, okay.
All right. I think she's on the trial docket for next month.
Set for trial September 8th. Is she going to still be in Georgia?
She's telling me she might be out by then.
Let's leave it on the docket and see what happens.
Yes, Your Honor. That's all I have, Your Honor.
Have a good weekend.
You too.
Spicy judges these last couple days. Hank Williams, Jr.?
This is a misdemeanor PTI.
Yeah. All right. So they'll give you some paperwork right there, and they'll give you I guess a county court date. Is that correct, Madam Clerk? Whatever the clerk tells you today.
Clerk runs this show.
I've given him reporting instructions.
We'll just get some paperwork.
Okay. They'll get you some reporting information. You're free to go. Good luck.
James Cotton. He's been evaluated for competency. There should be a report in the file. He's been deemed, it's the opinion of the doctor that he is incompetent, and they are recommending the state hospital. We have no objection to the report.
I've reviewed Dr. Charlotte's report. State had an opportunity.
Yes, I have.
Mr. Pereira, are you asking for another expert?
No, Your Honor.
Mr. Killian, you asking for another expert?
No, Your Honor.
I'm going to find that Mr. Cotton is incompetent to proceed, that the least restrictive measures available to restore him to competency is commitment to the Florida State Hospital or to the, for restoration under the Department of Children and Families. I'm going to do that at this time. And Mr. Killian, if you just prepare an order for that effect.
Yes,
okay?
sir.
All right, good luck. And we'll take him off the docket till we hear from the hospital.
Christopher Davis.
Busy court today.
Management. Okay.
And I'm doing another course.
They'll put you under oath. You can tell them all that. We're here for a bond reduction hearing, Your Honor.
Okay. You may call your first witness.
If he can, it'll be Mr. Davis himself. He can be sworn in.
My mom and my aunt.
Okay. And his mom is the aunt.
Okay.
Yes, ma'am. All right. State your name.
Christopher Ray Davis, Sr.
And where do you live?
At the moment is 5008 East 11th Street, Panama.
We don't need to know where.
Panama City area 4.
Since around 2018, sir.
Where did you live before that?
It was in Jackson County.
All right. Do you have any ties to the community here?
Yes, sir. I have my mom and my aunt and my work.
Where do they live?
My mom lives at the same address, 5008.
We don't need the address.
Lives, it's over on Panama City Cutoff, sir.
If you were to be released, where would you go?
Go to my mom's address, 5008 East.
We don't need the address.
For work.
I work for Armstrong Property and Maintenance. I do demolition, remodel, and finish on commercial and residential.
And you still have your job if you get out?
Yes, sir.
All right. And you've got some kind of certificate there. Do you want to tell the court about that?
Yes, Your Honor. I had just completed anger diagnostic. I have a certificate. And the Teen Challenge program that they have that's out on the outside right now, I have 3 courses left on that, and I have a certificate for that. And I talked to the pastor yesterday because when he gave me this, he said that if I am released that on bond, that I can actually come to the church and finish the program there.
What are you asking the court to do? Is there any amount of bond you would be able to pay?
Right now, sir, you know what I'm saying? I got my 2 family members out here, my mom, my aunt, that's all I got left. And they're both on disability. And like the 35,000, that's kind of high for my aunt. Like I said, when I'm on the outside, sir, I work. When my mom, my aunt, or any of my family members call, I'm always there. I drop everything. They could even vouch for that. I have my 18-year-old son out there that helps me out a lot. I have my other 2 kids.
Where do your other 2 kids live?
My 2-year-old lives with grandmother, and my son was just recently lived with my mom, but he moved out to the beach because he started a new job.
Do they rely on you for support?
Yes, sir.
And
moved out to the
what kind of support do you give them?
I mean, when my son needs money, like before he got the job, I've been helping him out with different stuff. Where recently he just got a Mustang, helped him out with that a little bit.
Do you pay child support or anything?
Yes, sir. I paid $366 on him.
All right, I have no further questions.
No, Your Honor.
Anybody else want to come and speak for Mr. Davis?
Just open mic night at the court. Anybody want to say a few words?
You don't have to if you don't want to.
If you'll come forward and raise your right hand to be sworn.
Stand in between.
Okay.
Yes, ma'am.
All right, what's your name?
Diana Mingers.
And what's your relationship with Mr. Christopher Davis?
I am his aunt.
All right. What do you want the court to hear today about him?
He's a good boy.
That's it.
If he was released, would you be able to keep him out of trouble?
I'll try.
Would you be able to make him show up for his court dates?
Oh, yes, sir.
All right. Is there anything else you want to tell the court?
We just need him out.
All right. That's all the questions I have.
Are there any questions?
No, Your Honor.
Any other witnesses?
No, Your Honor.
Judge does not seem swayed.
First witness.
I don't have any witnesses, Your Honor.
All right, what I'm gonna allow is Mr. Ferrer to make his argument, and then Mr. Key, I'm gonna allow you to respond to that argument. Mr. Ferrer?
Your Honor, the state's position is that this bond is more than reasonable considering the severity of the offense. It's a first-degree felony, sexual battery by threat of force. In addition, the defendant is already a registered sex offender. He has 11 previous felonies, including for solicitation of a minor, sexual contact. I think that the bond of 35 is more than reasonable considering the severity of the
Define
charges.
good boy.
We would ask for you to lower the bond to an amount that he can afford. That way that he can go back to work and support his children.
I agree with the state. I'm not gonna raise the bond today, but I think the $20,000 bond on the first degree felony is a more than reasonable bond, and the other bonds, there's both third degree felonies are reasonable. So I'm gonna leave the bond as it is and deny the motion to reduce the bond. We need another court date.
10/22.
I will leave that on 10/22.
We'll be in touch.
His lawyer had no faith that that was
See,
going to go through.
Mr. Hatcher, Mr.
He went through the motions, but that was it.
Downing, y'all ready? Or Mr. Saline? Ms. Downing? Okay. All right, Mr. Saline? Good morning.
Judge, I have two. The first one is State versus Xavier Harrell, 25-1480. CFMC is in Charles. Mr. Harrell is approaching. Judge, we were here earlier in the week on Wednesday for the violation of probation hearing, excuse me. Mr. Harrell had me file a motion asking to have bond issued. He's currently held without bond on the allegation of some new felony charges out of the state of Georgia.
Georgia wants
Would you
him.
like to call any witnesses?
Sure, I believe Mr. Harrell's the only witness, if he can be sworn.
Swear Mr. Harrell in? Well, all right. Put your hand down, and Mr. Saline, you may inquire whenever you're ready.
Thank you, Your Honor. Mr. Harrell, you're here this morning asking the court to issue a bond in this matter. If the court were to issue bond, do you have a place to reside?
Yes, sir.
Where would you be living?
My own house,
Where does your mother live?
Pickles, Georgia.
And there's some paperwork the state provided indicating the state of Georgia was not willing to take you back in light of the firearm allegations from the state of Georgia. Do you have anywhere in Florida you would be able to reside if Georgia refused to allow you to transfer back?
I have
Georgia
family
doesn't
down
want
here. I have to see.
Are they in Bay County?
You are banished
Where are they
from the
located?
state of Georgia.
In Tampa, Hillsborough County. All right. Would you have any type of employment? If you're not, where would you work?
I had a job at Walmart.
And do you think you could get one in Tampa?
Yeah.
Okay. Do you have any prior failures to appear?
No, sir.
Okay. And it's my understanding that you have not been to court yet, so those firearm offenses are still open in Georgia. Is that accurate?
Yes, sir. But I didn't get caught with no firearm.
Okay. So that's a typo that they
Yeah,
claim
that's
you're.
a typo. I didn't go to jail, no gun or nothing.
Okay. All righty. Any other reasons why you need for the court to issue a bond in this matter?
I mean, I got a job waiting on me, and I got twin little girls to take care of.
Okay.
20 or
I don't have any other questions, Your Honor.
I'm sorry, I said 20.
Sullivan, any questions? Mr. Saline, you can call your next witness.
Judge, that's the only witness. His mother did not choose to be here today.
All right, Mr. Sullivan, you can call your first witness. All right, I'll allow the state to make their argument, and then Mr. Saline, I'm gonna allow you to respond to that argument, make your own argument. Mr. Sullivan.
Judge asked that he remain held without bond. He was on probation for firearm offense. As Mr. Saline noted during his direct, the state of Georgia is not willing to accept him back.
State of Georgia says you're not welcome here.
All right. Mr. Saline?
Judge, the score sheet that we have indicates that there was never a prior criminal history until this incident in Florida, notwithstanding whatever may have happened while on probation. In the state of Georgia, it appears as though Mr. Harrell would have a place to reside in Tampa if Georgia would not be willing to take him back. He does have two little ones that he does help support financially. And so for those reasons, he's asking for an opportunity to be released.
based on the new law charges, I'm going to deny the motion to set bond. He'll be held without bond. What's the plea offer?
I believe with 24 months, I believe.
Yes, yes, Your Honor.
Is he going to score out that? Is he going to score over the 22 points?
He's right at the line.
All right, we'll set this for an evidentiary hearing. We've already set it for an evidentiary hearing.
Not yet, Your Honor.
Let's set it for an evidentiary hearing in September. I know October, is this your case? I will set it for October the 21st at 9 o'clock and at 1:30.
This judge is known to be sort of a hard judge.
Have a seat.
And Judge, the only other one I have should be on Zoom. If he appeared, it's a motion to withdraw with Mr. Pantanella.
Mr. Pantanella, are you on the Zoom?
Yes, sir.
Hello, hello. Turn on your
All right,
camera.
Mr. Pantanella, if you'll turn on your video.
Hopefully you wore pants. Yes. Well, he's got a shirt. That
All
works.
right. Mr. Saline, you may go forward.
Thank you, Your Honor. Judge, we're here in this matter. I had filed a motion to withdraw in the case earlier this month. I don't believe Mr. Pantanella has any objection. I believe he's requesting a public defender. He had lost his job shortly after I was retained and hasn't been able to financially get back on his feet during the summer months.
Sir, is that correct?
Yes, sir.
All right. Where do you live?
I currently live at
123 Sesame Street.
All right. I'm going to grant the motion to withdraw. I'm going to, Madam Clerk, whenever you're ready, if you'll swear Mr.
Fran, thank you for gifted membership.
Pantanella in,
It's very
and I'll
kind
take
of
some testimony as far as his financial situation.
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, the whole truth, God.
Yes, ma'am.
All right, sir, you can lower your hand and state your name.
It'd be Xander Vincent Pantanella.
Why is
Mr.
it dark?
Pantanella,
where
you're
he is?
asking for the public defender. Are you currently employed?
No, sir.
Do you have any money in the bank?
No, sir.
Do you have a vehicle?
Yes, sir.
What do you have?
I drive a Dodge Challenger,
What year?
2013.
Okay. So
Okay, what's it worth?
It's worth like
6,000.
13,000, I think.
Do you have any money on it?
Yes, sir.
How much do you have?
13,000.
About $7,000 left.
All right, is there any? Do you own any property or any real property or have a home?
No, sir.
Any money in the bank?
No, sir.
All right. And how many dependents do you have?
What does that mean? Sorry.
Do you have any
That's
children?
zero.
Everybody you take care
Oh,
of?
no, sir. No, sir.
If you don't know what it
Madam
means,
Clerk,
you have zero.
I'm going to appoint the Office of Public Defender to represent you. I'm going to give you a court date of, let's give him the October court date of October 13th at 1:30. Ms. Beasley?
It looks like Mr. Meredith will be his attorney if he can call our office. Sir, if you want to write down our phone number, it's 850-7
867-5309.
for Matt Meredith.
Thank you.
Welcome.
All right, that'll conclude your hearing, sir.
Thank you so
That's
much.
all I have. Thank you, Your Honor. I
Have a good
appreciate it.
day.
Have a great weekend.
Your Honor, I have William Hodges. This is with Mr. Sullivan. Mr. Hodges' case number is 262244. He told me that his dad has hired an attorney, so we're going to put off his bond motion
I'm going to set this for October 22nd. Is he already set for hearing?
just for today.
Yeah, September, he's set for September
Oh, yes.
24th, so we'll leave that as it is.
Okay.
Yeah. Thank you.
You're welcome. I have Joseph Howard.
Howard?
She's like, I know that guy.
Did you read it? You read it?
Yeah.
Okay, here, I'll let you do it. Your Honor, we have an agreement in Mr. Howard's case. He'll withdraw his previously entered plea of not guilty in case 262063. He'll enter a plea to count 1, possession of methamphetamine, a third-degree felony, maximum penalty 5 years in prison. Count 2 will be consolidated for purposes of the plea. Enter a plea of no contest to count 3, battery, a first-degree misdemeanor, maximum penalty a year in the county jail. He'll be adjudicated of all offenses. Time served on the misdemeanor, he'll have 24 months supervision on count 1. Court costs and fines of $1,028. 100 hours of public service work at the rate of 8 hours a month.
100.
$20 a month to be supervised. He'll complete a drug and alcohol evaluation and any counseling as recommended. 0 tolerance for use of controlled substances with random UAs at his own expense, and he'll enroll in that within 30 days. Provide a DNA sample if the state needs one. Forfeit any item seized will stipulate to facts and costs, and he must complete an anger management course as part of that supervision.
That's a healthy list of requirements for someone who's in for a drug charge. That they probably need a lot of help resolving the problem. 100 hours.
Placed under oath. Is that correct?
Yes, sir.
Mr. Howard, you're still under oath. State your name, sir.
Joseph Thomas Howard.
Mr. Howard, you able to hear what Ms. Beasley just announced?
Yes, ma'am. Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of its terms and conditions?
No, I'm not.
I've been handed a plea waiver consent form. There's the front page. Second page is a signature of the defendant line. Is that yours?
Yes.
Have you had a chance to read that agreement?
I understand it.
So you have a chance to go over your case with Ms. Beasley?
Yes.
Have you had sufficient time to speak with Ms. Beasley about your case?
Yes, I have.
Are you satisfied with your lawyer's advice and counsel?
Yes, I am.
You understand that by entering the plea, you're waiving your right to go to trial.
Yes, I am.
You're waiving your right to require the state prove the allegations against you.
I understand.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
I understand.
You're waiving your right to present any defenses that you might have to the allegations.
I understand.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
I understand.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
I understand.
You're waiving your right to appeal anything but an illegal sentence.
I understand.
Are you doing this for your own free will?
At my own free will, yes.
Howard, do you feel the pleas in your best interest?
Yes, I do.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
I understand.
Okay. I am going to find that Mr.
All right,
Howard's plea, I'm
understands.
going to accept the stipulation, find there's a prima facie case, and we'll find that Mr. Howard's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He's adjudicated guilty of possession of methamphetamine and battery. Possession of methamphetamine is placed on a term of probation not to exceed 24 months. He's ordered to pay fines and costs of $1,078. There's no restitution applicable in the case. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of probation officer. His cost of supervision will be $20 a month. He must undergo a drug and alcohol evaluation, follow all recommended counseling, 0 tolerance for use of any controlled substances not prescribed by a treating physician. He'll be subject to random UAs at his own expense. If he's required to give a DNA sample, he must submit one, forfeit any seized items. And he must complete an anger management course while he's on probation. On the battery, he's adjudicated guilty since the time he served in the Bay County Jail, given credit. Mr. Howard, you have 30 days to file a notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. You need to step over, be fingerprinted, and speak with the probation officer. Good luck.
Thank you.
Good luck with all those steps. That's a lot to do.
You're welcome.
Hope he's
I
got a
have
good support
Anton
network.
Manilove.
Antoine Manilove?
Your Honor, we're here on the docket today in case 253863. There was an order to show cause, but the person could not be located. I think we're in a position now to have a trial date, if we could set that for October.
All right, October, is that the state's position?
Yes, sir.
October 5th at 8:30, September 25th at 1:30 for trial management.
Just go over and sign, all right? And then I have Trifosia Scott.
That's a nice name.
Ms. Scott's
Trifosia.
case is 251604. We're scheduled for trial in September on the 8th, and I believe the state has a motion.
This one will not make the cut
Okay.
for our week.
What do we have? What are we going to try that week?
Well, did we do anything with Ballott's case with the trafficking? Is that one still on the Yeah.
At least sure we got enough.
There's the trafficking, there's McPherson, and Miss Beasley has another one. Those are the three that we're scheduling.
All right, when we want to set Ms. Scott?
Either an October trial or a December trial.
Let's say December 7th at 8:30, November 20th at 1:30 for trauma.
Yes, sir. Thank you kindly.
I also have Jacques Palmore. He's got a waiver, Your Honor. Case 22-2435, 22-4520. I believe we're scheduled for trial
Yes.
September the 8th in case 22-4520.
Yeah, this one's on.
We're going to leave that on the docket.
Yes.
All right, very good.
And that concludes my business for this morning.
You have anything else this afternoon?
I have one.
Is it going to be a plea?
I don't know. I tried to
Find
answer
out.
beforehand and it just wasn't successful.
If y'all can still reach, we got time. We can come this morning. Ms. Beasley?
She said she couldn't because of work. She took off this afternoon. We tried.
Try again. Tell her that I might not be here this afternoon.
Okay, I will do that.
Yes, you may. Just let Ms. Nelson know and she'll let me know. Sounds like a winner. I saw Mr. Sompley just come in, so he must be here for Mr. Batter.
Let's jump to Judge Capper. What do you think? Have we been here before?
On a signature bond, which means you're promising me I'll be in court when I'm ordered to be, or I'll
Audio's
have to
terrible.
pay a $2,000 penalty for not showing up. Plus, I'm making a condition that you go to get an assessment and start treatment. Methamphetamine's bad stuff.
We'll mess you
You gotta
up.
get off of it. It's not as likely to kill you as fentanyl, but fentanyl and methamphetamine are the two most common drugs, I would say, in our community right now. The problem with getting meth off the street is you don't know that you're not getting some fentanyl, and fentanyl is really dangerous. Meth and over the long haul will do bad stuff to you, but it's not good.
The judge
It's
has
highly
a.
addictive. So.
Wow. He's
Let's
done-
come back maybe a couple
Meth
of
is
weeks
pretty
or
bad,
so,
guys.
See where she is. That would be the 4th of September. Yeah, that'll work. September 4th is her next hearing. Thank you. You're welcome.
State of Ohio versus Donald Malone, case number CRA 26297.
Sir, you Donald Duane?
Yes, sir.
Got an aggravated possession of drugs charge on you. You have a right to remain silent. You don't have to say anything. You do make statements. They can be used against you. You have a right to have an attorney.
This judge
and
has
have
the
one
biggest
appointed if
nameplate.
you can't afford one. To have bail and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The state's alleging on March 24th of this year in Perry Township, you knowingly were in possession of methamphetamine, Schedule II substance. That's a felony 5, maximum penalty is a year in jail, $2,500 fine. Do you understand that charge?
Yes, sir.
You had to make hire a lawyer.
No, sir.
Are you working?
I've been incarcerated on this charge for, right around 70-some days now, because I got picked up over 100 on this morning. And
We're going to jump
extradition
back
over
to
there
jail court.
on June.
Because this noise is just too much. It's already It's already grating in my ears. We're going to jump to jail court where we've got a lot of people lined up to see the judge here. And she holds court right there in the jail, it looks like.
Bryce Flores. Mr. Flores, you've been charged with a Class B misdemeanor interfering with public duties. I do find probable cause for that charge and set your bond at $1,000. Do you want a court-appointed attorney?
Yes, please.
Do you have any questions?
What did you do? Speak out at a
Free
city
to go make
council
your
meeting?
phone calls. Amanda Galvan. Ma'am, you've been indicted in cause number 2015-407072 out of the 304th District Court for a third-degree felony securing a document by deception alleged to have occurred December 26th of 2014. That bond's been set at $1,500. Do you want a court-appointed attorney? Yes. Do you have any questions? No. Free to go make your phone call. Christopher Gonzalez. Gonzalez, you've been charged by the DA's office and cause number C-26 CR 1499 the County Court Law number 2 for a Class A misdemeanor assault domestic violence alleged to have occurred January 20th of 2026. That bond's been set at $3,000. And I show Charles Blevins is representing you. So we'll appoint him to this case as well. Do you have any questions? You're free to go make your phone. Valdemar Gonzalez. Mr. Gonzalez, you have a warrant out for you in cause number PFF 2026 WNT 0111 for a third-degree felony alleged to have occurred on 2026. That bond's been set at $100,000. Then you've been charged with a third-degree felony, possession of a controlled substance, penalty group 2 between 1 and 4 grams. I find probable cause for that charge and set your bond at $2,500. Additionally, on the warranted case, there are conditions of bond that have been entered against you, and these are those conditions that you abide by the conditions of bond until disposition of this case. You commit no offense against the laws of this state, any other state, or the United States. You avoid persons or places of disreputable or character. You maintain total abstinence from the use or possession of alcohol, narcotics, marijuana, drugs, dangerous drugs, controlled substances, or any other substance or intoxicant unless prescribed. You'll submit non-dilute samples for testing of drugs, alcohol, and other substances at the direction of the pretrial services officer. You will be added to the UA call-in line. You will attend and complete any counseling or rehabilitation as recommended by your officer. You're not to possess any firearm or other weapon. You're to report in person to Lubbock County Pretrial Services before 11 a.m. on the first business day following your release and bi-weekly thereafter. You're ordered not to have any contact directly or indirectly or communicate with J.H. and Presley White or go within 500 feet of any residence, school, place of employment, business, or location frequented by them. You are to remain at your residence except to travel to and from your place of employment, attorney's office, and other essential places as approved by the pretrial services officer. You're to be home between the hours of 8 p.m. and 6 a.m. unless prior approval has been obtained. You will have a GPS monitor placed on your person prior to being released from this facility. There's one other condition that's lengthy, so I'll allow you to read it. So if you want to come up here.
I'm not going to read it to you. It's too
Take
long.
the paper down if you want to. It's a little bit high. So this right here, I'm full.
Can you read it out loud so we know you understand?
When did this incident occur?
It says August 8th of 2026. So week before last. So if you want to sign saying that you understand, if you'll put your date of birth there and your signature there, and then you'll get a copy upon release. I do show that
No, my wife.
I cannot at this point. I show Lorna Walcott as your attorney.
Oh.
Lorna Walcott. So speak to her and she can file a motion with the court to reduce your bond, okay?
For this charge,
Mhm.
Lorna Walcott.
Walcott. You're free to exit. Thank you, sir. Randy Higgins. Ms. Higgins, you've been charged with a Class B misdemeanor theft between $100 and $750. I do find probable cause for that charge and set your bond at $1,500. Do you want a court appointment? Do you have any questions? Jacob Honorato? Sir, you've been charged with a third-degree felony in possession of a controlled substance, penalty group 1 or 1B between 1 and 4 grams. I'm actually reducing that to a state jail felony less than a gram. Having found probable cause for that charge, I'm setting that bond at $2,500. You've also been charged with a second-degree felony, possession of a controlled substance, penalty group 2 between 4 and 400 grams. At this time, I don't have enough information to establish probable cause on that charge, so I am releasing you from that charge. That doesn't mean the case has been dismissed. If the DA's office has more information, they could recharge you with that. But at this time, you'll only have to make bond on the first charge. Do you have any questions about that?
For my call, I left my little number in the last pocket when I took a shower last night.
Okay, well, just ask the.
You got
Ask
the,
the
go to the
officer.
desk where you did your mugshot and go wait patiently for it.
Yes, sir.
Do you want a
Gotta wait
court-appointed attorney? Okay. Yeah, go ask one of the officers when they get a chance and they'll help you out, okay? You're free to go make your phone calls. You're welcome. Elijah Jorge? Sir, you've been charged with a
phone calls aren't
first-degree
free.
felony, possession of a controlled substance with intent, penalty group 4 and 200 grams. I do find probable cause for that charge and set your bond at $15,000. And I do show Robert Sullivan's representing you on some other matters, so we'll appoint him as your attorney on this case. You have any questions?
He'll love to
You
hear
have
that
a
you
city
picked up another
ticket, so if you'll
charge.
have a seat, that judge will be right with you. Isaiah Morales. Sir, you've been charged with a Class B misdemeanor, driving while intoxicated. I do find probable cause for that charge and set your bond at $2,500. Do you want a court-appointed attorney? Do you have any questions? All right, the city judge will be right with you, okay? Kurt Moore.
Do we think that this lawyer has?
Mr.
or
Moore,
this
you've been charged with a
judge-
Class B misdemeanor, driving while license invalid with a previous conviction, suspension, or without financial responsibility. I do find probable cause for that charge and set your bond at $750. Attorney,
Do you think she's reviewed all this for
have any
probable cause?
questions?
I mean, there's one. She said there wasn't
free to
probable
go make
cause.
your phone calls. Brandon Pearson. Pearson, you've been charged with a Class B misdemeanor, criminal trespass of a building or property. I do find probable cause for that charge and set your bond at $1,000. I do show Orlando Oripez is representing you on something else, so we'll appoint him as your attorney on this case. Any questions?
No, man.
All right, you do have a city ticket, so if you'll have a seat, that judge will be right with you, okay? Winston Reed. Mr. Reed, you have a warrant out of Scurry County and cause number 26AW00446 for a second-degree felony, aggravated assault with a deadly weapon. That bond's been set at $50,000. Do you want a court-appointed attorney? No? Do you have any questions? Yes, sir. All right, you're free to go make your phone calls. Brandon Sanchez. Mr. Sanchez, you've been charged with a Class A misdemeanor violating a protective order. I do find probable cause for that charge and set your bond at $15,000. I am placing a 4-hour hold on you. What that means is that once you
Hello,
make
hello.
bond, the jail will hold you an additional 4 hours before releasing you. And I show Mark Snodgrass is representing you on another matter, so we'll appoint him as your attorney on this case. You have any questions? You do have a city ticket, so if you'll have a seat, that judge will be right with you. Shane Smith. Mr. Smith, you've been charged with a Class A misdemeanor, resisting arrest, search, or transportation. I do find probable cause for that charge and set your bond at $2,000. You've also been charged with a Class B misdemeanor, criminal trespass of a building or property. I find probable cause for that charge and set that bond at $1,000. You want a court-appointed attorney?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right, you're free to go make your.
Just getting word right
You're
now
in
of a sword attack at a school in Sweden where multiple people are injured. You don't hear that very often, but just coming across the news. Hopefully everybody's going to be okay, but scary.
Misdemeanors for resisting search or transportation. I find probable cause for each of those charges and set each of those bonds at $2,500. You've also been charged with a second-degree felony, assault against a peace officer. I find probable cause for that charge and set that bond at $5,000. And then you've been charged with a Class A misdemeanor, driving while intoxicated, second. I do find probable cause for that charge and set that bond at $3,500. I am also placing an order for ignition interlock against you. What this order states is that you need to have the ignition interlock device installed on any car you drive within 2 weeks of your release from this facility. And then I am also placing conditions of bond against you as well. These conditions state you'll abide by the conditions of bond until disposition of this case. You'll commit no offense against the laws of this state, any other state, or the United States. You'll avoid persons or places of deplorable or harmful character. You'll maintain total abstinence from the use or possession of alcohol, narcotics, marijuana, drugs, dangerous drugs, controlled substances, and/or any other intoxicant unless prescribed. You'll submit non-dilute samples for testing of drugs, alcohol, and other substances at the direction of the pretrial services officer. You'll attend and complete any counseling or rehabilitation as recommended by your officer. You're to report in person to Lubbock County Pretrial Services before 11 a.m. on the first business day following your release and monthly thereafter. And then you will have that ignition interlock device installed on any car you drive. Do you have any questions about these conditions?
I own a vehicle, but I'm legally blind, so I don't drive it. Somebody else drives me everywhere I go.
Okay, well, you were driving a vehicle at the time of this offense. So when you get behind the wheel of a car, it must have the ignition interlock devices on it. I am gonna have you come up here and sign these orders. Your
Another reason
signature
not to
states that
drive.
you've received a copy. I
Oh
mean,
my
excuse me,
goodness.
that you understand them. Yes, ma'am.
I'm legally blind.
You'll sign right here.
Are you sure I need that on my car? Ma'am, you were pulled over drunk driving.
And then the.
Maybe that's a
ignition
defense
interlock,
to
if you'll
drunk
sign right
driving.
there.
Legally blind. Oh my goodness.
Go make me phone calls. I'm sorry, Ms. Stone, do you want a court-appointed attorney?
Yes, ma'am.
All right, thank you.
Thank you.
All right, Mr. Wheeler, you have a warrant out for you in this case for a bond forfeiture and cause number CC 2025-0556 for a Class A misdemeanor resisting arrest, search, or transportation. That bond's been set at $8,800. Do you want a court-appointed attorney?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Or you go make your phone calls?
Thank you.
Mount Wilkerson? Mr. Wilkerson, you've been charged with a statement evading arrest or detention with a previous conviction. I do find probable cause for that charge and set your bond at $3,500. You've also been charged with a Class B misdemeanor, failing to leave information, causing damage to a vehicle more than $200. I find probable cause for that charge and set that bond at $1,500.
Looks
You
like
want
he
a
hurt his
court-appointed
hand too.
attorney?
Oh, yes, ma'am. So what's the total?
5,000.
5,000.
Any other questions? You do have a couple of city tickets, so if you'll have a seat, that judge will be right with you. Cesar Zapata. Mr. Zapata, you've been charged with a third-degree felony possession of a controlled substance, penalty group 2, between 1 and 4 grams. I find probable cause for that charge and set your bond at $2,500. Then you've been charged with a Class B misdemeanor, possession of marijuana less than 2 ounces. I find probable cause for that charge and set that bond at $1,000. Do you want a court-appointed attorney?
So what's that in total?
$3,500.
Like 15% of that?
Well, about $500. Okay. You do have a city ticket, so if you'll have a seat, the other judge needs to see you.
She did the math pretty quick.
All right, Judge McNamara will be right with y'all.
Right with
Anybody out
y'all.
there that can see these two Zooms? I can call them. Yeah. Yeah, you just need to see the other judge. Okay.
Wow, they're fast at that. Flying through that. Apparently, she's reviewed all the cases, done all the work. It is 11:36. We're going to be going to Las Vegas in in just a few minutes. I think in about 10 minutes, 9 minutes. So we're going to wrap up our court hopping here and have just a little bit of a break for me to run and grab some waters. Hopefully, if I can find some. I think we're out of water. We need to run to the store. I must have my Deer Park water. Not a sponsor yet, Deer Park, but not for a lack of trying on my end. Good stuff. So, how am I feeling from the late night streams? I'm trying to adjust my schedule, but it's starting Monday. We're doing with our kids that are still in elementary, junior high, and high school age. We're doing a co-op for homeschooling, and it starts early. So I've got to be like on the road doing a carpool because there are like 3 families in our neighborhood that we're taking. I've got to be on the road by 6 a.m. and then I'll drive them again from one place to the second on around 7:30. So that's going to be early mornings, and then we're going to work late here in the nights. It's going to be a rough trial for me. It's a rough trial. I'll have to take some naps during the day, so you guys have to cut me just a little bit of slack if I close my eyes just for a wee moment during the day, just to get some rest. But either way, we're gonna be going down to Las Vegas here in just a minute. We don't have a live feed yet from court, but we will in just a second, I think. So we'll be picking that up here at 11:45. Expecting a full day of court, as this will be 9 o'clock start for Las Vegas, and they'll be going until 5 o'clock this afternoon, which takes us right to the 8 o'clock hour here on the East Coast. So, long day, but the court, oh my goodness, this trial's getting so good. I'm loving it. It's getting great. I'm really starting to see the defense lawyer. I like him. I just don't think he knows what he's doing. This is not his area of expertise. This defense of murder. It's a big case to have it be your first one. It's a big case. Let's get ready for more recordings. I don't think we have a lot of recordings. We got through most of those yesterday. There were 5 hours. We had 4 of them, so a little bit more. After stream, check Mod Chat. My to-do for you. Thank you, Troy. Appreciate that. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again in about 6 minutes. We have a portal set up so you can portal right over, grab somebody's hand. We'll just suck you in through the
Remember
magic.
in the beginning when we started 110 years ago?
I do, Laura. Thank you. Magic of the interwebs. We're going to just suck you right down to Las Vegas and get ready. Buckle up, because day 5 is about to begin. I like him. He puts his foot in his mouth with some of his questions. Oh, does he ever? Yeah. And Mr. McDonald, I'm not putting your client in prison. You're putting your client in prison. That might be all too accurate. We'll see how that goes. You guys, we'll see you in just a little bit in Las Vegas. We'll portal over to the other stream right now. We'll see you. Bye.